Yes, Mr. Roberts.
I was finishing up on DMG in the Court of
Yes.
Appeal. So you have the decision. Lord Justices Jonathan Parker and Ricks both say, yes, the claims were pleaded.
Yes.
That's for Jonathan Parker, paragraph 247, which is page 258.
Yes.
And for Lord Justice Ricks, paragraph 257, which is page 261. Lord Justice Buxton disagrees. You want to read it later. The reference is paragraph 292, which is at page 272. The debate between them is not one of principle, it's just how to construe those pleadings. There is a point of principle that I take from the case that I submit is important, which is one they all agree on. So could we please look at page 260 of the decision, of the bundle, paragraph 252 of, yes, is that right? 252 of Lord Justice Ricks. And the first sentence, it says, I agree with Lord Justice Buxton, a claim in restitution, each payment, the return of which is claimed, constitutes a separate cause of action. The Lord Justice Buxton says that at paragraph 293 as well.
293.
293, page 272, and he cites Lord Gough. So it's not, I think, a new proposition, but I thought it was helpful to illustrate it from this case.
And is that something with which Lord Justice Jonathan Parker agrees?
Yes, I believe so, though I don't have the note for where he says that, so I may need to come back to you on that.
Well, Lord Justice Ricks says, para 250, on the cause of action issue, I agree with Lord Justice Jonathan Parker and Lord Justice Buxton. So somewhere Lord Justice Jonathan Parker must have said.
I think it's paragraph 246, actually. If you look at the end of paragraph 252 of Lord Justice Ricks, he says, in this respect, Jonathan Parker's approach is no different. See paragraph 246. So they all agree on the principle. And the important point is that causes of action are then individuated by reference to individual payments. And it must follow, I then say, a cause of action can only be alleged if it refers to the payment said to found that cause of action. At least in a general matter. There might be a question about whether it's alleged with sufficient particularity, but it has to be alleged. The only other point I wanted to make on the law before we finally get to the pleadings is somewhat anticipatory, and I'll reserve most of my time for reply, but at Core Bundle, tab 20, page 319, there's a paragraph in my learned friend's skeleton.
Sorry, just a minute. Let's hold on a minute. Core Bundle, tab 20.
Page 319.
Yeah. Yes.
My learned friend just refers there to two cases on GLOs and says the approach is in line with that. I'm not sure where he wants to go with that, and so I'll reserve my position for reply. All I would say is our case is what my Lord Lewison held in Prudential in the Court of Appeal, so this GLO in the Court of Appeal, that the proper approach to pleading is as set out there. There's no GLO bypass to that pleading. I don't say that's my learned friend's submission, I just say that's our position is that what Lord Justice Lewison held in that case is correct, and the passengers for your note are Authorities Bundle, Volume 3, tab 29, and paragraphs 12 to 20, which are at page 919 to page 922. The position may be common ground, as I say, so I won't say any more on it for now. So could we then turn to what was pleaded? And for this, the question is, again, whether the pleadings will look at plead the causes of action individuating those payments set out in the statement of case that I showed the court. The claim form, the original claim form, is in supplementary bundle, tab 1, page 3. And the brief brief details of claim, they're on the claim form. Paragraph 2 is the only relevant one here. It says there are claims for restitution of monies paid. Compensation is irrelevant. That was because there was a debate over whether this was Frankovich or unjust enrichment. Restitution of monies paid, ... pursuant to a mistake of law and or demands. That's what we get. Two obvious things to say. It doesn't say what money is paid. It doesn't say even what the category of money paid is that we're dealing with here. There's also nothing about the mistake. There's nothing about there was a credit that we didn't apply, led to an overpayment. So we say that doesn't take us anywhere. And the particulars over the page at page 3, the two crucial paragraphs that have to be read in conjunction are paragraphs 3 and 7b. And could I just ask the court to read those two paragraphs? So 7b seeks restitution of monies paid by the claimants in the circumstances referred to at paragraph 3, pursuant to a mistake of law and or demands. So we need to look at paragraph 3 to see what the mistake and demands were. And paragraph 3 says, the receipt of dividend income gave rise to an immediate tax charge, underline that, on the claimant receiving it. So there's a generic allegation there to money being paid in those circumstances. And we say that's all, in generic terms, what I set out as stage 1. There's no specific reference to what I called stage 2. And there's no particularity at all about the actual payments. There's no reference to any years there of money being paid. While we're on this, it might be helpful for me to show you now what the judge said on this particular part of the pleading, which is at core bundle.
Do we need to look at the schedule, or does that not matter?
Over the next page, the points we make on that would set out in the skeleton argument and say again, that is all stage 1 tax being paid. That's one point. Another point is you'll notice to period ending 2002. There's nothing there saying, and in 2018 and 2019, there'll be tax that we'll be paying. There's no attempt there to particularize some future cause of action.
What is the force of the words monies paid or liable to be paid?
Well, I'm not sure. You can't have restitution of a liability that I'm aware of. I think it's trying to be belt and braces for if there is a liability currently in existence but perhaps money not paid yet pursuant to it. They couldn't have that by mistake because they've issued the claim form. They must know that there's no longer a mistake. But they might have it on a Woolwich claim. So ultimately the claim would perhaps be for the monies paid and they're attempting to get future payments. But I'm not sure I can help further in a sense it's for my learned friend.
Well, I wonder if you go to paragraph 7b, particulars of claim, on one reading, one of the things they're asking for there is a declaration that the claimants are not chargeable to corporation tax for monies liable to be paid.
So the
Possibly.
restitution is just of monies paid. The declaration is the liability.
Possibly. I mean, it's not it's not the most natural reading of that paragraph, but
Although you could say that the whole of 7b is conditioned by, in the sentence is referred to in paragraph 3 above. Paragraph 3 above talks about the receipt of dividend income. Dividend income is defined by paragraph 2 And that's tied to the accounting periods referred to in the schedule. And the accounting periods referred to in the schedule only go up to 2002.
So it can't be still a liability, as my lords thought.
Well, it could be, we've paid this money for accounting periods up to 2002, and we may have other we may still be under a liability to pay.
Right. So, but then it would still be the declaration here that they'd be pleading. They can't be pleading restitution of the liability, and they can't be pleading restitution of future payments. What they could say is, if for under liabilities, we're putting you on notice, as it were, if we pay them, we're going to want them back. And then if they pay them, then they can amend and claim them back.
You could certainly seek a declaration as on the law as we know it now. If the failure to carry forward GTR credits is in breach of the EU law.
Absolutely. Yeah, you can seek declarations even about the future, and that was a change made. So this is not. I think it's relevant. There was a change made by the Judicature Acts that you could have them as to the future, and so it's been jurisdiction since then, and the rules of the Supreme Court introduced after the Judicature Act to allow that. They had to introduce it because there was no power absent that change to allow for declarations about future rights. And so then the question becomes, I think it's Guriat, there's a Lord Diplock case on this, whether it's too hypothetical for you to seek a declaration about the future. But in principle, you can. So they could seek a declaration that taxes we pay in the future will be ones we can recover.
Okay, but just going back to the cross-reference to paragraph 3, we think fairly emphasised the word immediate. Now, however you view the Salonen tax charge, I don't think the CJEU or the Supreme Court applying it would say that the tax in 2017 and 18 was an immediate tax charge. Under the law as we know it now, you wouldn't plead this way. It might have been more relevant when it was thought that you shouldn't have been able to set the losses, etc., against the immediate tax charge. But we're now told that's not the right way to look at it.
We agree, my lady. I mean, if in a sense you say this isn't how you plead it now, that's maybe all I need. Maybe I need a bit more than that. But the fact that the immediate tax charge doesn't refer to the later payments is my point on this. They're not referring generically to stage 2 payments.
Yeah.
So they don't even get to what will be my second, as it were, line of attack or defence, depending on how it's phrased. Whether if they refer in the generic sense to those payments, have they given enough particulars to have pleaded the cause of actions that they seek to bring?
There's a difference between not pleading something and pleading it and not particularising it.
Precisely so, yes.
I mean, if you simply plead, I paid tax which I wasn't liable to pay, it cries out for particulars. It's not a case of not having pleaded a claim at all.
Well, it depends. So if you plead, I paid tax which I wasn't liable to pay, and that was it, and then you, for example, take the facts of this case, the claim was stayed, and then 15 years later you paid tax, and you said, well, that's within the genus that I pleaded there. That won't be enough. You'll have to say that the actual cause of action was alleged. Wasn't it? It has to be alleged. If it's alleged, you can add further particulars, cure it. If it's not alleged, you will, if you put in further particulars, be introducing a cause of action, and then you'll run into the limitation issues. My lord's of course right. You might sometimes, suppose, in a sense, it's the DMG. DMG decides this. The court holds, rightly or wrongly, it doesn't matter. Payments in 94 and 95, or 95, 96, were alleged. But they didn't say how much they were. When they had the schedules, they're adding particulars. But they had alleged they made payments in those years. That must be what the courts held. So the particularity there was not fatal to them having pleaded the cause of action. But
One approach is to say, is it capable of particularisation? It was in DMG.
Yes. Yes, one has to be...
In this case, it's only capable of particularisation in the sense of specific payments later.
in my submission, it's a helpful rule of thumb. It might not completely answer the question, because if you think of the Hurst example I gave you where it's allowed in, if you do plead the right, sorry, when it's not allowed in, if you do plead the right kind of claim, ACT payments, this kind of injustice, and you allege it from 1989 to 94, there is a sense in which giving the 1995 payment is giving more particulars of the same claim, broadly conceived. But it's not enough, because by adding that particularity, you're introducing a cause of action. So what my lady says in my submission is correct.
Well, maybe I should qualify it by capable of particularisation at the relevant time.
Well, even then, in DMG, it was capable of being, in Hurst, it was capable of particularisation at the relevant time when the claim form is issued. They just hadn't pleaded the later cause of action. So if you're not pleading, if you don't plead enough that the cause of action alleged is in issue, you can't cure it with further and better particulars. If you plead the cause of action, but you don't give enough particulars to specify, was it £100 or £1,000? Something like that. You've pleaded the cause of action, and you can then cure the deficiency that might make it liable to be struck out with further and better particulars. But that's because you're not introducing the cause of action. The cause of action was always there, it was just imperfectly particularised. I hope that's responsive.
Right, you wanted us to see what the judge had to say about it.
Yes, I think that's still worth doing it. Core bundle tab 7, page 118.
Are those the only iterations of the particulars of claim that we're concerned with?
No, we can look at the other ones now if you like. I was just going to briefly look at the judge.
Whatever suits you.
Let's look briefly. No, in fact, let's just do all the particulars now. Let's get through it. I think we're quicker. Can I briefly, though, say what I say on these particulars? I think you might have all the points, but just in case. 3 points. First, there's no generic reference to the stage 2 payments. We've discussed that with the court. And it's in that sense distinguished from DMG, because it can't be cured by particulars. Second, even if the court is not with me on that and thinks, as the judge did, that there was some generic reference to the stage 2 payments, there's still no particularity about individual years. And the shining example of that is the 2018-2019 payments.
So just to be clear, you say 2018 and 19, are those when the payments were made?
Yes.
The tax years are
year before.
1 year earlier.
Yeah, but the cause of action is not the tax year.
Yes.
It's the, yes. But
Just
my lady's exactly right.
Well, you say there's no particularity of any particular year, but the schedule does include payments up to 2002.
Yes, my lord is quite correct. No particularity of any payments for individual years in respect of the stage 2 payments. So the schedule is all stage 1 payments.
Yeah.
As I understand those particulars.
And the third point?
Could I briefly on the second point and the future causes of action, I just wanted to say I have been unable to find any decision under either the CPR or the RSC where anyone has ever said you can plead a cause of action that hasn't accrued in that sense. I take it Mr. Bremner hasn't either, because there's no reference to one in his skeleton argument, but we might see. That is the effect, though, of the judge's decision. And it might be worth reflecting on why that's never happened before. In the ordinary case, claim is issued. If facts happen post-dating the claim form before trial, one amends. And normally there's going to be no real objection to that. Indeed, even in this GLO, Prudential amended post-issue of the claim form to plead further payments. No one's going to object because it's the same facts, it's just new causes of action, there's no limitation problem. Here, it's different. 2010 comes, the ouster comes in, so they can't plead the 2017, 2018, 2019, depending how you individuate it, payments, because they'd be ousted. So they're driven to argue, they pleaded them all along to get around the ouster. But that's the reason why no one's done it before, because there is a normal method for dealing with fresh causes of action. you allege them, and then you have the usual argument over it.
I don't want to be too mischievous, but if DMG was right, you can plead a cause of action before it's accrued.
Well, DMG wasn't right, of course. So, you know, I have the Supreme Court on my side on that now, but is that right? I'm not, that might be too difficult a question for me at 2:15. I'm not sure.
Actually, I don't think Section 32 tells you when the cause of action accrues. It tells you when the limitation period starts, which is not necessarily the same.
True, but they say you can't discover the mistake because the mistake didn't exist until. I mean, that's the difficulty that my lords put me on. So it's a slightly Schrodinger's cat kind of problem, I'm afraid. And, you know, the oddity was the claimants were alleging that they issued these statements of claim years before they could have discovered the mistakes, which is, as Mr. Ewart said, odd. Actually, in this case, they've issued statements of claim alleging mistakes that they haven't yet made, which is also odd. It's in a sense the same problem, because they say in 2017 and 2018 they were mistaken on the basis of facts they alleged back in 2003. So it's a similar sort of puzzle.
Do they don't need to rely on mistakes for 2017 and 2018 because they're within the 6-year limitation period? Why don't they have a perfectly good woolage claim?
Well, they can't rely on the 6-year limitation period now because 2017 and 2018, if they're new claims, are caught by the ouster.
The ouster, but it's not a limitation problem.
No, that's right.
It's an ouster problem.
Yes. The third point my lord asked me is simply to say there's no reference to the injustice that is alleged, the mistake. You don't see anywhere you failed to set off DTR credits that resulted in an overpayment.
Well, there is an allegation that the payments are pursuant to a mistake of law.
Yes, there is no particularity about what that mistake is. And as Lord Burrows showed us in Samsuna, you have to allege the precise mistake because it's not enough just to say I was mistaken. And notice the mistake that they allege is about the incompatibility of the treaty, but that isn't the mistake they'd be relying on at stage 2. They have to rely on the DTR credits because that's the reason why they make the payment. They'd have to be able to say 2018, 2019, we didn't know we had these DTR credits. That's why, if they're relying on mistake, that's why we made the payment, because we didn't know that. They don't say that. And in a normal case, you then have cross-examination, did they believe it, didn't they, and so on. But there's nothing there that would allow that to be an issue.
In a normal case, you'd ask for particulars of what was the mistake.
Well, you might simply seek to strike it out rather than, but it amounts to the same thing. Briefly on the other particulars, supplementary bundle, again, please, page 9. They start, and could we please look at paragraph 13 of those, which is on page 12.
So is this the last set
No.
before the 2010 changes? I assume that's why it's in the bottom.
There are numerous iterations of the particulars of claim and claim form, not all of which are in the bundle. The 2009 iteration is the version that was in play at the time of the commencement of para 51 sub 6.
That's, yes.
And that's the one we got
That's
tab
these.
2.
Yes. I'm grateful as ever to my management. And we then have the latest ones as well in the court.
Yeah.
Paragraph 13, you can see how the mistake is particularised. And you can see it's paying the corporation tax on dividend income at paragraph 2. We say that's a stage 1 payment, not a stage 2 payment. And it's the same for paragraphs 14 and 15 when they're referring to release. It's talking about corporation tax on dividend income and the use of reliefs in that year. It's not talking about later years.
It's not quite as clear as the original from your point of view as the original one. You don't have the reference to an immediate tax charge.
That's correct, my lady, although we don't, I think, have anything other than a reference to it being tax on the dividend income. There's no suggestion of the carry forward later tax being paid, but I accept the deletion of the immediate. Correct.
Where's the definition of dividend income in this situation?
Paragraph 2, page 9, third line, first sentence.
It's all accounting periods from 1974, including but not limited to those in the schedule.
Yes. To make sure I don't squeeze my leader too much, I might summarise, if I may, what I say about the other pleadings, and I can come back to and reply if need be. The other ones are all post-date, the ouster. Those are the fourth amended particulars that are in the core bundle at tab 9. Because it post-dates the ouster, I say it can't help the judge or my learned friend on those payments. Either his case was properly pleaded before those particulars, in which case he doesn't need them, or it's after the ouster, in which case they won't help him. What I'll say about that.
Is there a relation back point or not?
The relation back, there's an order we can look at allowing amendments, but they're amendments without prejudice to any of the points that one might take or limitation and so on. So I don't think, or I'll hear what my learned friend says, I don't think he says those, as it were, cure his problem if he does have a problem with the earlier pleadings.
The key point is, doesn't para 51 restrict relation back?
That's what I was wondering.
I see, yes, as well. So I thought what your lordship was asking about, can they get around the ouster, as it were, through things we agreed?
That's the question,
Yes.
because the normal position is that an amendment relates back, and there's a restriction if it's statute barred, or might be statute barred, but that's not the question here. So the question is, does paragraph 51 prevent a relation back? And I think
The answer is yes. Yes. Sorry for answering a different question. The other pleading that's referred to, but I think not relied on, is the reply. The only point I'd say on that is you can't introduce a cause of action in the reply, so it's again not going to help anyone. Can I summarise then? Well, maybe let's turn now to the judge's reasoning. That's in the core bundle, tab 7, page 113. His discussion begins there at paragraph 107. I think we can skip over to paragraph 114, which is page 117. The stuff before that is summarising the legal position. Page 117, he's then looking at the pleadings.
Yeah.
I think he's just setting out the bits to which I've drawn the court's
It's
attention.
paragraph 120 where he comes to his decision.
It's precisely right, my lord, yes. So the judge says, paragraph 120, he doesn't accept our argument because, first, there's a claim for a declaration. My answer to that is it doesn't matter there's a claim for a declaration, we're asking about the restitution. So unless you can somehow construe them together, that won't help. I say you can't construe them together. One, because it doesn't work semantically. Two, declarations are juridically different. We've actually discussed that earlier.
Yes, you say a claim for a declaration is not a claim for money.
Precisely. The claim for monies, the judge says, is enough, as they have there. Moreover, that's that sentence. In respect of monies paid, he says that's sufficient because both Salonen and the Supreme Court have established the difference in treatment we've discussed. It is, in effect, an unlawful tax on overseas dividends. It's worth reading this with paragraph 125, because I think it's the same point being made by the judge. So he's again saying paragraph 25, page 120, a claim for restitution of tax overpaid at stage 2 is in effect a claim for restitution of tax on overseas dividends at stage 1. I think that's the same arguments that have to be read together. Two points in response. First, to say something is in effect something else is to say it's not the same thing. So I have just some difficulty understanding exactly what the analysis is there, but it seems to be stage 2 payments are unlawful because of the injustice at stage 1, the indirect, double taxation. We agree, but so what? The question is whether the stage 2 payments are pleaded. And if they've only alleged stage 1, the fact that stage 2, if it arises, is unlawful in virtue of stage 1 doesn't help. Notice stage 2 might never arise. Depends on whether corporation tax is incurred. That's the first point. Second point I say is, even if I lose on that, the judge's analysis is still insufficiently granular because he's just referring to claims. He has to ask whether the particular causes of action were alleged, and there's nothing here to explain why he says they were. That's most striking, of course, for the payments post-dating the claim form. A striking instance of that, if could I draw your attention while we're here to paragraph 126, the last sentence is his conclusion. To that extent, AXA's claim might have failed for want of particularity. However, in my judgment, for the reasons I've given, it has still pleaded.
John, where are you?
Last
yes,
sentence,
last sentence
paragraph
of 126,
126.
yeah.
He underlines pleaded. Can I strike that underlined A? He says it's pleaded a claim based on unjust enrichment. Well, that's a rather telling indefinite article, if I may say so. That's not the question. The question isn't did they plead a claim in unjust enrichment. The question is did they plead the causes of action they want to bring. So you may ask rhetorically, well, if they did, where are the 2017, 2018, I don't know how you phrase it, payments? We say they're not there. We say none of them are there, but we say those in particular really are not there.
Well, you have two different points, as I understand it. The 2017, 2018 payments, your point at its simplest is you can't plead a cause of action which hasn't yet accrued. But that isn't an answer to the 1994, 95, 96 payments. But you still run the argument in relation to the early payments which have taken place, because you say, when you read the pleading, it's not dealing with stage 2 payments at all. That's a different point.
Correct, my lord. I agree. I'm sorry if I didn't make them sufficiently distinct. There are, in a sense, maybe 3 stages to it. One, is there stage 2 are there stage 2 allegations at all? If no, I win. If yes, which do they allege the claims preceding the claim form being issued? If yes, they win. If no, I win. Stage 3, do they allege those? Can they allege and do they allege those post-dating claim form? And we say they can't. If they can, they didn't. The only other point to say on this is paragraph 123. It's really a point we've discussed before. The judge says, well, this is just a failure of particularity. That's why he says it's a DMG case. And I've made my submissions on that. We say it's not a failure of particularity. It's not like saying we paid you in overpaid tax in these years, but you don't specify how much. They don't specify the type of claim. They don't specify all of the years. And to the extent they do specify the years, because of the first reason they don't specify the type of payments. Mr. Bremner, in his respondent's notice, doesn't seek to add any reasons on this. That's a core bundle, tab 17, page 241. So I don't expect him to seek to say anything other than what the judge said is correct, and it wouldn't be open to him to do so if he wanted to. Could I briefly look at the ouster issue? Unless the court has any more questions on the pleadings. Now, given what I've said on this, then this only arises in respect of the 2018 or 19 payments. The early ones are pleaded or not. But, and it only arises if the court does think that those payments are in some sense pleaded. Because if they're not, then we don't get to the ouster issue. So the court has to have concluded it's possible to plead a future cause of action, and they did so. Then the question is, if they did so, is it ousted? The relevant paragraph 51 of Schedule 18 is in the Authorities Bundle, tab 16, page 131.
Okay.
131, tab 16. So the paragraph applies, subsection 1 says, where a person has paid an amount by way of tax but believes tax is not due, or they've been assessed as liable. Paragraph 2, a person may make a claim to HMRC. Subsection 6 over the page says they're only liable in respect of the statutory claims, Tax and Management Act or other provisions. And then the commencement that, again, I think is common ground is claims made on or after 1st of April 2010. That's a couple of pages back at page 129, section 100 of the Finance Act. Now, we say they never made the claims, and that's the pleading point. If they did make the claim to the 2018-2019 payments, we say they're ousted by this from ever asserting them. Those claims notice had not crystallised into causes of action, so no one's being deprived of a cause of action by this. And the question is really, what does the statute mean at 1 and 2? We say, subsection 1 and subsection 2, we say it presupposes, at subsection 1, that a claim can only be made after there's been an assessment or they've paid the money. Then they may make a claim. That happens here, or could happen, it never did because they never made the claim to it, but it could happen after the 2018-2019 payments, then they're caught. The fact there's the earlier allegation of that means there is a sort of husk of a cause of action that has not yet accrued, but we say it's still possible to oust it as a complete cause of action, because otherwise you'd be able to plead these things long in advance and avoid an ouster by staying the proceedings. So I think that's all that is actually at stake on the ouster.
Yeah, can I just clarify? I think I misspoke earlier when I said there was a relation back provision here. It's not here. I think the answer may be that relation back works for the purposes of the Limitation Act. So there's no need to address it here. This is a self-standing statutory provision. I think we had a discussion earlier about the answer to my Lord's question.
It did,
And
yeah.
it doesn't have on its face, and I did think...
I had in mind 320 actually. I said it in three.
So did I,
Yeah.
and that was my mistake. I think the answer may be that when you look at the Limitation Act, the relation back is for the purposes of that.
That's right. So section 35 is where relation back comes in, and then part 19 is where they deal with it. If you are seeking to introduce a new claim, it's defined there, and claim includes cause of action or new party, then if there's an arguable limitation defence, you can't do that. Now, my learned friend says we didn't add a claim because we had one from the start. The only point, I think, is even if they had one from the start, then this Act is still seeking to exclude it if it's only accruing later. Because subsection 1 says you can only make claims to HMRC once the tax has been assessed or paid. Because otherwise, one can just walk around ousters. That's, I think, the only point on ouster, because...
the word claims is not defined in section 100, as far as I can see.
No, I didn't.
So it must be referring to claims under paragraph 51. And those are claims for either repayment, where somebody has paid something, or discharge, where someone has been assessed as liable to pay something.
Yes.
So claims must be claims either in respect of monies paid or an assessment of liability. Right?
We agree, yes.
Yeah.
Yes. I must, I'm afraid, be very brief on this. The judge simply says it's the same issue, ouster and pleading. And it is if we win, it's not if we lose, if you see what I mean. Mr. Bremner raises some more points in his respondent's notice. Before I set them out, one further point on the 2018-2019 payments, if I may, because it is quite striking. It's not one of those issues where you see it, it seems odd, and then on analysis it makes more sense. I think it gets worse on analysis. The 2018 and 2019 payments, causes of action hadn't accrued yet. Suppose there was a full trial before then. Judgment is issued, order is made. Then they make the payments. and they say, well, we want them back, we would be able to say on their case, you can't because your causes of action have merged with the order. That's a striking position that we say can't be right, but that is the logic of the judge's decision on my learned friend's case. Mr. Bremer's respondent's notice, his skeleton argument is probably more helpful for this, and maybe I will just briefly summarise. We've dealt with one of the points he makes, which is the meaning of claims. We say claims is what my Lord Justice Lewison says means. We don't say there's anything peculiar about our construction. The other point he says is there'd be no remedy at all, so EU law wouldn't allow you to oust them. Respectfully, we just don't understand that. The remedy is under the statutory provisions, and people have pursued those. When my learned leader, Mr. Hewitt, referred to the post-Prue claims, those are all people who've issued claims under this provision. AXA could have done that and chose not to, but it now has to live with that choice, which is its claims live or die.
I take it they're out of time.
Yes, I wouldn't be saying it otherwise.
There's a four-year time period.
I believe that's right.
Is it compatible with EU law to have
Well,
a time period which might expire before you know of your mistake?
we say yes, they were not them, maybe the same team, but not those claimants will say no. That is, as I understand it, I'm not instructed in that, one of the issues to be determined in post-Prue by this court. So there is a separate question of whether the ouster is EU law compatible.
But we're not asked to decide.
No, it's not an issue here. Could I look behind me before I... Okay, my learned leader says he will explain, my lord. So that may be, unless the court has any further questions, the time for me to drop a row back. Right. Thank you very much.
Can I just deal briefly with that point, just so we're not... there is no, my recollection, there is no issue about this ouster in the post-Prue litigation. What it's all about is whether they made claims and whether they were in time. Broadly speaking, there's a number of issues about that, including claims of this sort in relation to stage 2. So that's part of the post-Prue litigation. What they have to do and did they do it is an issue in that case. But in broad, it is in principle open to them to make the claims. The question is, have they satisfied the correct procedure? And the answer to your other question is there's clear European law authority that limitation periods, or reasonable limitation periods set in advance, are not incompatible with EU law. And that is even in the case where the limitation period is expired by the time you find out that you've got a claim. There were a number of cases in Hard Petroleum, I think they're actually in the bundle possibly, April, where that point was raised, where by the time they got to the court, they were out of time to make the claims, and the court said that's just life. Limitation periods are important as a matter of protection of, certainty and all that kind of stuff. So there's clear authority. I think that point is also made in a number of the GLO cases. The problem arises when you when you take away a limitation period without notice.
Yes, you
Because
impose
then
a new limitation period. There's no transitional protection.
Exactly. Then you've got a problem. That's Marks and Spencer's and Section 320 and whatever. But if you do what we did and was done with Para 51, which was to introduce the legislation, but say it didn't come into force for 8 or 9 months, that's okay, because then they've got 8 or 9 months to bring their claims. And after that period, the shutters come down. So there is a transitional period. That's what satisfies European law, broadly. But if you've got a limitation period that's been in existence for years, there's nothing wrong with that. And in fact, that's a point I'm about to is relevant to issue C3. So, issue C3, which is something slightly different from what we've been dealing with. An introduction to it is in the judgment, paragraphs 132 to 136 of the judge's judgment, he deals with the background to this issue. And if I could just summarise, companies normally, UK companies normally pay corporation tax, as you're probably aware. But in some circumstances, they can be liable or at least bear income tax where they receive payments on the deduction of income tax. That's explained in paragraph 132. They can then set that income tax can be set against corporation tax for the year in question. There's a set-off provision. And if it's not set off because there's no corporation tax, then they can recover it, or they can recover it. And there's a time limit for that. That's why the time limit problem, same time limit problem that Just Nugee was mentioning, comes up. So what happened in this case? We're dealing with a £500,000 payment of income tax, which was carried, which was to be set off against corporation tax in the year. That happened in the sense that at the time, the parties believed that the corporation tax was due, and therefore the income tax set off against it. In fact, now we know, having gone through all this litigation, that the true position in that year was that some of that corporation tax was unlawfully charged. And so, in the words of the Supreme Court in Prudential, was effect a nullity. And the question that we have in this issue is what happens in those circumstances, where the position was at the time that we now know that the tax was unlawful. And what the revenues say is that, as in the same way what happened in Prudential, the set-off didn't take place to the extent that the corporation tax was unlawful, because there was nothing to set off, and that the remedy would have been to recover the tax under the statutory provisions. And of course, the time limits for that have long since expired. Now, the judge's answer to this was that no one would have understood this to be the position at the time. We say that's the wrong approach to take to this kind of situation. It's an aspect of the declaratory theory, and indeed it's the way that the declaratory theory of judicial decisions says, as you know, a court makes a decision now, that has always been the law. So the law in 1995 was what the court now declares it to be. And indeed, all of the claims in these GLOs have been based firmly and squarely on the declaratory theory, because the claimants have been saying, in 2008, the court has now decided that payments of corporation tax liabilities that we thought we incurred in 1980 were in fact unlawful. And they were unlawful at the time under the declaratory theory, and therefore we made a mistake at the time in paying the tax, and that's why we're able to recover it. Or alternatively, in more recent years, the demand which was made for it was unlawful. Although nobody knew that at the time, in fact, it was unlawful, because we now know that the tax was not lawfully due. So, in a real sense, the declaratory theory underpins the entire claims in these GLOs. That's what they rely on. That the decisions of the European Court and of our domestic courts all apply right back to the time when the time when we entered the EU in relation to some issues, and in relation to these issues we've been dealing with back to 1990, which is when the free movement of capital provisions were brought in.
So what you're really saying is the judge is being inconsistent. You can't, on the one hand, rely on a later decision to show that there was a mistake, and yet on the other hand, not follow through the consequences of that mistake.
Exactly, yes. So the correct way to analyse this is to look at what we now know the law to have been at the time and apply that to the situation that occurred at the time, which is exactly what the Supreme Court did. I showed you the passages about ACT. They said, well, although at the time everyone believed the ACT was actually set off against the corporation tax, we now know it wasn't. In fact, that wasn't the situation that actually occurred at the time, because there wasn't a corporation tax charge in reality, because it was unlawful, and therefore there was no set-off. And we say this is a similar situation where, although everyone thought the income tax was being set off against corporation tax, under a provision which is very similarly worded to the provision in ACT provision, in fact it wasn't. And it's no answer, one, to say nobody would have thought that was the position at the time. And it's also no answer, I think, as the judge also says, to say, well, if that's right, then they can't recover the income tax now because they're too late. And that's the point I was making to Lord Justice Nugee, which is there's no breach of the principle of effectiveness in EU law. If you apply a limitation period, either a statutory one or either a Taxes Act limitation period or a period under the Limitation Act, which is fixed in advance and is a reasonable length. I don't think anyone's suggesting this wasn't a reasonable length. The problem they have is, of course, as is the case in many situations, we know, by the time that the claimants realised they had a claim, it was too late to make it. And that's just commonplace, of course, not just in these GLOs, but in life. You very often might discover you had a claim 20 years ago, but unfortunately, you can't make it anymore.
All those personal injury cases where people didn't realise they were injured, or there are building cases where nobody realised the building was defective.
Well, there's Pirelli, wasn't that
Exactly.
Pirelli was the classic case, wasn't
Yeah.
it? The defective premises. Now that was cured by, well, attempted to be cured by statute, wasn't it, by extending the limitation period. But in principle, that's the answer.
And it goes back to cartilage and Joplin, so that's why you've got
Yes,
potential extensions of time under Section 33.
yes. And that's why the claimants in these cases have relied so heavily on Section 32(1)(c), because most of their claims are in periods that are outside a normal limitation period of 6 years. Many of them going back to the 1970s in FII, which is why the amounts of claim were so great, because of the interest, mainly from 1970. But anyway, that's what we say, that this is simply a misapprehension about the nature of the exercise that is being carried out in this case and in all of these cases. So the fact that they wouldn't have occurred to them that this was the analysis is not an answer, and the fact that it wouldn't have occurred to them to make a claim for the income tax is not an answer. What we have to do is grapple with the legislation, as the Supreme Court did in Prudential, and ask the question, well, was there a set-off at that time? And we say that this is indistinguishable. I don't know, what Leonard Friend may say something else, but we say it's indistinguishable from that position. The analysis of the Supreme Court in Prudential should apply mutatis mutandis to this. Would it be helpful if we just looked at that again briefly? I know we've looked already. It's the Supreme Court in Prudential. It's in bundle 3. It's tab 32. And it's paragraphs, first of all, paragraphs 97 and 98. Yes, sorry. Paragraphs 97 to 98. where they say, in addressing this issue, the starting point is to recall that an entitlement to repayment or restitution in this context requires that there's been an unlawful charge to tax as a result of incompatibility with EU law. The question we are asked to consider is, in substance, have the revenue unlawfully levied ACT by setting it against MCT, which should be unlawfully charged. But there is a logically prior question, which is whether there has been any set-off. Company A may have received income which has funded its distribution from UK resident companies and also from companies resident elsewhere in the EU. In this computational issue, the court is not concerned with unlawful ACT, which has been charged on a distribution by Company A derived from income which is received from an overseas resident company in the absence of sufficient credit for foreign tax on the latter's company distributions. That's just a very long way of saying this is not unlawfully charged ACT. It was perfectly lawfully charged ACT. We're concerned with ACT, which is unquestionably lawful, which has purportedly been set up against an unlawful MCT charge on Company A. And then they deal with the, set out the arguments for PAC in that case. And at 101, they continue, in our view, the revenue are correct in their submission that if an apparent charge to MCT was unlawful, that charge was a nullity. The ACT could not have been set against a nullity, but remained available to be carried back if a claim was made under section 2933 or for automatic set-off against lawful MCT in a subsequent accounting period under section 2394 or otherwise to be utilised. So that's a reference to the statutory provisions as regarding ACT and how they can be used. Being so available, the lawful ACT did not directly relate to the unlawful MCT in the same accounting period, in the sense that penalties and interest may relate to an unlawfully levied tax. Accordingly, the revenue in receiving payment of the lawful ACT did not receive unlawfully levied tax, which gave rise to a San Giorgio claim. I think what the claimants had been arguing was that, in some sense, the ACT franked the unlawful MCT and should be recovered. That was their case, and I think that was in fact what the Court of Appeal had decided earlier in the FII case as arose, and that's what's being rejected here. Further, PAC was obliged by ICTA to pay the lawful ACT. The payment of the ACT did not entail a defective transfer of value, which falls to be correct. The ACT was due when it was paid and was available to PAC to utilise thereafter. And that's the same with the income tax here. There was no problem about the income tax that was charged by deduction in this case. It was perfectly lawfully charged. PAC's loss in the context of issue 3, i.e. in relation to lawful ACT, is the result of the levying of unlawful MCT and through the misunderstanding of the law, which it shared with the revenue, of its not having been able to set the unutilised ACT against its liability for lawful MCT in the same or other accounting periods, or otherwise to utilise the ACT to reduce its liability to loss. Its loss in that sense does not support claim in restitution, and they refer to an investment trust. We are informed that PAC's corporation tax liabilities in its accounting periods from 94 to 98 are not finalised, as PAC's returns in those years are still open, and that therefore it may be possible for PAC to carry forward unutilised ACT to set against its MCT liabilities in those periods. But whether or not that is the case, in agreement with Mr. Justice Henderson and FII, we consider that an inquiry into whether, and if so how, surplus ACT would otherwise have been used within the group of companies cannot give rise to a claim in restitution. It would form part of a claim for damages if the criteria for such a claim were met. So what they're saying is, if they want to argue that if we had known about this problem, we would have done something different at the time, and therefore we've suffered loss, that's a claim not in restitution, but a claim in damages, which they would have to show sufficiently serious breach, etc. Because the arguments on these issues previously, if I remember, had been about the question, is this really a claim in damages or really a claim in restitution? So we say that is the approach that ought to be adopted. That was the approach we were urging on the judge. Perhaps we could just look at what the judge said about this. So he starts in paragraph 137 by making it clear that he's focusing on the £500,000 because the £200,000 had been dealt with and it was all agreed, settled. And it's £500,000 that is under principles of FII Supreme Court 3 to be treated as available for carry forward. And then he makes the point I've mentioned, or one point at least is clear, in 1995 it would not have occurred to AXA that any part of the corporation tax liability it had discharged by means of a notional carry forward of underused DTR. In saying this, I'm not of course making any finding as to the date of constructive knowledge, he says under 32(1)(c). However, even if AXA had known or suspected that it had been given £500,000 too little DTR, it could scarcely have realised that any surplus DTR could be carried forward to 1995, since UK domestic law at the time set out no liability for unused DTR to be carried forward. I therefore agree with AXA that HMRC's argument involves undertaking a notional reconstruction of AXA's 1995 corporation tax computation, under which carried forward DTR that AXA could not have known was available is set off against a notional corporation tax liability that AXA could not have considered due because of the availability of credit for income tax. Well, having to unpack that, that's rather compressed. What he seems to be saying is, first of all, this was a notional reconstruction of the corporation tax position. Well, in my submission, it's nothing notional about it. It is an application of the later decisions to the facts of the case at that time to give the correct analysis as to the position in 1995. He also seems to suggest that the corporation tax liability was notional. And the reason for that, it seems to be because it was satisfied at the time, or at least it was thought it was satisfied by the income tax payment by way of set-off. But of course, the fact that it was paid by set-off doesn't mean the liability didn't exist. There was a corporation tax liability in 1995, or at least there was thought to be a corporation tax liability.
But the whole point is that there wasn't.
We now know there wasn't, exactly, yes. It's quite right that they couldn't have known that there wasn't a liability. But what the judge seems to be suggesting here is that, in fact, there wasn't a liability at all in 1995 because of the availability of credit for income tax. So I think what he's confusing is there was no corporation tax which had to be paid in cash, but there was a liability, or there was a perceived liability which was perceived to have been satisfied by the set-off. That's the true position. AXA submits that HMRC unsuccessfully argued for a similar notional reconstruction in FII Supreme Court 3, but then he agrees with HMRC that their argument in the Supreme Court 3 was different from that now made. We were arguing that domestic legislation on the set-off of management expenses against income could be construed in a way that would prevent those management expenses being set off against case-filing income, such as non-UK dividends. HMRC advanced that conforming construction with a view to persuading the Supreme Court that it would remove a central cause of the problem identified in Para 108. That's right. In a sense, that's right. What we were arguing for was that the answer to the conundrum of Salonen was to carry forward the management expenses, displace them and utilise the credit. But anyway, that was simply the mechanics as to how.
But what's maybe important is that what the Supreme Court actually decided was that it was lawful to set off those losses and management expenses against what, if paid in cash, might be an unlawful tax, the tax on the dividends earlier. It wasn't a nullity situation. Those losses were actually used.
That's right. Yes.
Because the Supreme Court decided that the remedy was the carry forward of the DT.
Yes, that's right. But what they were dealing with then was was there a corporation tax liability at all? Because if you applied the management expenses, there was no corporation tax liability to be unlawful. Whereas what we're talking about here, of course, is that there is a liability, but it's being discharged by set-off. So there's, yeah, they're different. I think they're different points. So he then says, if this feature of the tax landscape was removed by HMRC's suggested conforming instruction, it was argued that the problem identified in Para 8 would arise. The taxpayer would have a notional corporation tax liability of 30 on a gross dividend of 800 and would be fully satisfied with DTR of 30 and would retain the ability to carry forward management expenses. So that's just setting out what our argument, which was rejected by the Supreme Court, was. HMRC's unsuccessful argument, summarised at 141, was not therefore directed at the question of which corporation tax liabilities carried forward DTR should be set against. Rather, it was an attempt to persuade the court that there was no need for taxpayers to have the ability to carry forward DTR in the first place. HMRC's argument failed because the court considered the root cause of the problem was the DTR legislation was contrary to EU law. Therefore, to address that was by means of a conforming construction of DTR legislation, rather than a conforming construction of provisions relating to management expenses. I think that's all correct. However, AXA is on much stronger ground when it submits that the notional reconstruction of its 1995 corporation tax computation that HMRC is inconsistent with all the Supreme Court analysis at 154 to 158. These paragraphs must be read together with 146. The following points emerge. It's necessary to identify the extent to which tax was paid as a result of the inability to carry forward unused DTR credits. The requisite transfer of value necessary for a claim and restitution is present if a payment of corporation tax was made under the mistaken belief that unused DTR could not lawfully be carried forward and set against the corporation tax liability. So that's what we've called stage 2, I think, that they're referring to there. That's where the restitutionary claim would arise. If we didn't have the complications of set-off, if you simply had a liability that in 1995 that you had satisfied in cash, so you paid the corporation tax in cash, what the Supreme Court was saying in Supreme Court 3 was that we now know that was unlawfully charged because of the carry forward, and therefore you can recover it in restitution under mistake because you made a mistake. Even though at the time, of course, everyone thought the charge was perfectly lawful, and in fact it was a charge on other income. Remember, we're not talking about charges on dividends at stage 2, we're talking about tax paid on something completely unconnected with the foreign dividends. So applying the logic of this case, no one would have dreamt that someone paying corporation tax on something completely unconnected with foreign dividends would end up having it declared unlawful by the court 20 years later because of the foreign dividends. I mean, but that is the law. It doesn't matter whether you'd have thought it was the law, that is the law. A restitutionary claim is available because EU law does not permit the indirect double taxation of foreign source dividends when domestic source dividends are exempt from tax. And that's right at a high level of generality. That's the sort of problem that it's dealing with. HMRC's analysis is premised on the proposition that £500,000 of corporation tax in AXA's 1995 accounting period became unlawful when it was not mitigated by a carry forward of surplus DTR. With respect, that is the position that the Supreme Court, in Supreme Court 3 said was the position. It was unlawful. However, there's no basis for that proposition in FI Supreme Court 3. The whole focus is on the need to identify tax paid as a consequence of a mistaken belief that underused DTR could not lawfully be carried forward. Well, I'm sure that's right, that the Supreme Court did not have in mind this slightly obscure situation in which corporation tax was discharged by set-off of income tax. It's not a very common situation. They were no doubt talking about tax being paid to illustrate the general proposition that it was unlawfully charged, and therefore if you paid it you could get it back. But that doesn't limit the generality of what they were saying about the effect of carrying forward surplus DTR. My learned friend has taken me to the passages. I'm not going to take you again in Supreme Court 3, but what the revenue was saying in Supreme Court 3, one of their arguments was, look, this later tax charge in year 15, when it's been carried forward, or year 10, on some other income completely, was perfectly lawful. Nothing unlawful about it at all. And therefore you can't recover it in restitution by mistake or whatever. This was tax on some other profits completely. The answer they gave was no. If you carry forward a DTR credit in this way and you set it against corporation tax in a subsequent year, that corporation tax is unlawfully charged in some retrospective, in some way. And therefore you can recover it in restitution. That's the whole burden of the Supreme Court decision. Without that, there would be no remedy for the taxpayers. The carry forward of DTR would be all it would give you was perhaps a damages claim or something, I don't know. But they said no, the Supreme Court said no, it is unlawful and therefore it can be recovered. So that's exactly what the Supreme Court said, and we would submit. And it can't matter whether the tax was discharged by cash, income tax set off, or indeed ACT set off. If there was a carry forward to a year and the corporation tax was unlawful because of that, Prudential would tell you that any ACT that was set off against that corporation tax would not be set off because the corporation tax charge was a nullity. So we know that. We know that that would apply exactly in the situation of ACT. The question you've got is, would it apply to the income tax set off in the same way? And we say there's no distinction. So they then say the Supreme Court says we're concerned with the payment of tax, not with its non-payment. Well, that was in the context of deciding whether, what they were saying there was that we're looking at payment of tax and recovery of tax. But they weren't saying, well, if it was paid by way of set off, we're not interested in that. They weren't. It wasn't before them. I have to accept. Nobody said, well, what happens if it's paid by set off? But there's nothing in the decision that limits this to payments in cash. The actual tax paid will necessarily relate to amounts shown in actual tax computations. Well, of course, there were actual tax computations here, one imagines, computing the amount of corporation tax that was due. It's simply that rather than paying it in cash, it would be recorded as paid by set off, the income tax. HMRC effectively argue that AXA should have made a claim in 1995 for repayment of income tax and must therefore suffer the consequences. It's now too late for such a claim to be made. Well, I'm afraid that is what we argue. That's absolutely right. To say they should have, well, they could have. In practice, it probably wasn't going to happen in 1985 because they wouldn't have thought of it. But in a sense, that is what we say, that would be the remedy in this particular situation.
And that would be a claim in court or under the statute? Or
a statutory claim. There are provisions, sorry, they're in the skeleton that give you a right. If you can't set off the income tax, you can recover it. You make a claim to recover it. It's a statutory, yeah, it's part of the statutory code. However, the only basis on which it said AXA could have made this claim was a notional rewriting of its actual tax computation for 1995, which HMR now advanced some 20 years after the event. There was no realistic prospect of AXA making the claim which HMR said they should have made in 1995. Therefore, the effect of the analysis is denying any restitution of indirect double taxation of foreign source dividends arising as a consequence of a mistaken belief that surplus DTR could not be carried forward. Well, that's true if you look at this from the point of view of today, or when this claim is, when the judgment is being written. But that proposition would apply to the whole GLO, because there were and indeed lots of other situations, because there's lots of situations where we now know there was unlawfully tax charged years and years ago, but it's just too late to recover it. There's nothing special about this particular situation. It's too late to recover it, but it's not because we are imposing a notional reconstruction. We would say it's simply because that is the way the law works, as declared by the courts, including Supreme Court 3, and all the cases that have gone before it that have built up to it.
So does this really go back to the question of engaging the principle of effectiveness? Here you've got a tax levied, turns out to be in breach of EU law. There has to be a remedy, got to be an effective remedy, and a prospective limitation period satisfies the principle, even if time runs out before you realise you've got a claim.
Absolutely.
That's how it works.
That's what we say.
Yeah.
Exactly, and that is the. It's difficult to see why this case is special, whereas every other case, that's exactly how it works.
So the last couple of sentences of paragraph 144 of the judgment should be read as what? Indicating the judge's view that the principle of effectiveness was breached?
It seems like that he's saying, well, it can't be right to deny AXA the ability to recover this money from 1995 now.
Therefore, the principle of effectiveness has been breached.
It must. Well, he doesn't say that.
I know he doesn't say that.
No, but what he then says is that to cure that, I'm going to adopt a different analysis, a different legal analysis. It doesn't mean that the £500,000 is the income tax is lost. I think what he says is that it carries forward to the next period, because otherwise they wouldn't be able to recover. That seems to be the reasoning. They wouldn't be able to recover now because they're out of time. Therefore, it can't be right. Therefore, we will carry the £500,000 credit to a subsequent period when it would result in a claim to get back cash.
Why can't that be the effective remedy?
Well, it's not a question of that's not a question of because there is no breach of effectiveness in the first
So
place.
you say the fact that there was an ability to make a statutory claim to repay the income tax sufficiently satisfies the principle of effectiveness, and you don't need to fashion any other remedy.
Yes, but it's not really a remedy he's fashioning. And I think what he's doing is changing the analysis, because he's then saying he's changing the substantive sort of legal analysis. He's then saying, well, the DTR credit, because you can't recover it from that period, it must carry forward to the next period, because you can't recover it now because you're too late. The only way that you're going to be in time to recover some kind of restitution or remedy is if we carry it forward to a later period when there was a cash payment, and you're then able to hopefully recover that in restitution. Because for that, you've got a longer time limit. You've got section 32(1)(c). They hope. All of this would be academic if they can't rely on section 32(1)(c), obviously, because they would never be able to get back to 1995 without it. But that's the reason that they're arguing this particular primary point. They want to be able to say, well, it arises in a later year. We've got a claim in restitution which we can take back to that year. So I'm not sure it's exactly fashioning a remedy, but it's having that effect. It's changing the analysis so that you have a different remedy that has a longer limitation period. That's essentially that's the result of this. And unless there are any more questions, I think I'm slightly over, but we're pretty much on line.
Thank you very much, Mr. Hewitt. Yes, Mr. Bremer, your reply.
I'm obliged. If I can start, please, with issues A and B. And on that, if I can begin, please, with the limitation issue and what was at issue in Prudential and what was decided there. 5 points. First of all, yesterday, my own friend submitted that the explanation for what was being decided in Prudential High Court was all to do with the Woolwich claims and how far those claims could be related back. Your Lordship will recall that at about 3:45 yesterday. First of all, there is no support for that in the contemporaneous document. There's mention on a couple of occasions, both yesterday and today, of the revenue skeleton in Prudential. That document is not in the bundle before this court, for the very good reason that the revenue skeleton in Prudential did not address limitation at all. Completely silent on that question. I showed your Lordship the passages, or at least the most relevant passages of my learned friend's submissions in dealing with the limitation issue in front of Mr. Justice Henderson. And your Lordship will recall that was where there was the exchange where it was said that if section 320 is invalid,
This is the bit of the
points were
transcript.
academic.
Yeah, the bit of the transcript, yes.
So supplementary bundle, page 25, pages 246 to 247. If one reads through 246 to 247, the sort of significance that's now being attributed to Woolwich is just absent. The point is, as we've just said, that my friend's position is that if section 320 is invalid, the points are academic. And that, of course, is entirely consistent with my case on what was at issue in Prudential, because one only gets to section 320 if section 32(1)(c) applies as a matter of principle. What section 320 does is it turns off what would otherwise be the application of section 32(1)(c). So it's not an answer in my submission for learned friend to say, as he said several times, there was nothing in the claimant's skeleton or from the claimants about section 32(1)(c). The very fact they're talking about section 320, and we did see that in the claimant's skeleton, that's consistent with what I say the understanding was, both parties and of Mr. Justice Henderson, as to what was at stake. That if section 320 fell, section 32(1)(c) applied. My own friend also said in this context, well, it was all very different in the FII GLO. Your Lordship will recall that point being made this morning. And true it is that the formulation of the issue in FII was different to the issue that was there at trial in the Prudential test case. But I would just observe, and again, none of this is in the bundle, but we have to check the history of this. In FII High Court 2 in 2014, no skeleton from the revenue dealing with the limitation issue, no cross-examination that went to the issue of limitation, and equally no oral submissions on the limitation issue in 2014 in front of Mr. Justice Henderson. And in this court, FII Court of Appeal 2 in 2016, again, no skeleton argument from the revenue on limitation, points on limitation introduced for the first time orally. And yes, they were dealt with by this court and an order was made, and that was what was then appealed to the Supreme Court and what became FII Supreme Court 2. But I do say that the description of how these issues were being organised, it is something of a rewriting of history. And the position actually is much more straightforward. Your Lordship has my point. We had limitation as a GLO issue. The issues were refined in the CFC and dividend GLO litigation as set out by Mr. Justice Henderson in paragraphs 248 and 249 of his judgment. That is what's decided, and the order and the passages in the judgment that I've shown the court, they are the judgment and an order in relation to the GLO issue of limitation.
Yeah.
So that's point one, just in terms of how the matter was argued. Point two is that the explanation that's being advanced by the revenue, it's also not consistent with Mr. Justice Henderson's judgment in Prudential High Court. We know And if you'd like to turn it up, Prudential High Court, it's tab 29, start of volume 3 of the authorities. And we've looked at this already, so I'll take it short. It's page 908. And we know from the procedural history, paragraph 249, particularly 249 little d, that the claims go back to 1990. And the court will recall that's outside the ordinary 6-year limitation period. So for those claims to succeed, the claimants there need the benefit of section 32(1)(c). And what Mr. Justice Henderson addresses in terms, for example, in 255 on page 910, is PHL's ability to pursue, first of all, claims in respect of payments made before 14th of July 1998, and in terms, it is mistake-based claims. For example, in line 5, that's what he's dealing with. And if we look at those issues on relating back, suppose PHL was able to relate a Woolwich claim back to 2004, and the original claim from it would still only have been able to go back to the 14th of July 1998. So that's why I say that the explanation that's being offered for what was at issue and what's being decided, it's not reconcilable with contemporaneous materials, it's not reconcilable with the judgment, and it's also not reconcilable with what's set out in the order, in particular Declaration 8 capital A and paragraph 3D and 5, which makes clear that the claims are upheld, and they're upheld going back to 1990. The third point I need to...
Before we move on, can you explain the final sentence of 259?
Not easily, my lord, no. It does, on the face of it, look like there may have been a slip in the language. I was reflecting on that overnight, and I'm happy to reflect on it further. But it is
It's puzzling, isn't it?
it is puzzling, and certainly I am still in a state of puzzlement. It looks like there's been something that's gone slightly wrong with the rendering in that final sentence.
The ACT claims, if they arise out of the same facts, you can get them back to 1990, 2003 and 2004.
Yes, so take PAC, you'd get them back to 8 April 2003, and PHL, you'd have got them back to 14 July 04.
Yes, but presumably they're dated back more than 6 years.
They went back to periods including 1990.
Thank you.
I mean, it may be that leaving aside, it should have said apply. It should have said if 32(1)(c) applies, but I'm having to, I'm having to rewrite those pages in the brackets. At the moment, I can't offer anything better than that, for which I apologise. I'm going to reflect on that again overnight, but my reflections of last night didn't get me any further forward in being able to answer that question. The third point that I need to deal with is the suggestion that was canvassed that the wording of issue 1, and your lordship will recall that's set at 248 sub 1 on 908. That's the to what extent is the claim statute barred by 6-year limitation period. It was said, well, that formulation sort of itself, that the nature of the way the issue was formulated meant that it couldn't be a GLO issue. That doesn't work. That isn't introducing some sort of claimant-specific, fact-specific inquiry that can only be relevant to PAC and PHL, and means that it's not an issue that raises common or related issues of fact or law. The reason for that is that the answer, which one certainly gets out of the order, whatever one may say about the reasoning and the judgment, the order, paragraph 3D and 5, are crystal clear. The answer to that issue is that the claims are not barred to any extent by a 6-year limitation period, and indeed Declaration 8 capital A tells us in terms that those claims are in time. It's the tailpiece to Declaration 8 capital A. And we don't need to go back to it, but it's page 70 of the supplementary bundle. We've looked at it.
But as Lord Justice Nugee pointed out yesterday, claims are barred by a 6-year limitation period. The only question is, when does a period begin?
So, and I'm so sorry, I said Declaration 8, I meant Declaration 11, and I should have said page 71. At least I can correct that for the transcript. That in my submission is it would be a reading of the paragraph 248 sub 1 issue that robs it of its context, because what one has to take a step back with all of this. This isn't a game. This is not a game. Prudential has been designated as the test case because, for very good reasons concerning the efficient administration of justice, it is thought that the best way of getting rulings that will sort out this large group of claims is by having a test case. And one of the issues that it is agreed by the parties and endorsed by the court, and I showed you, Lordship, Mr. Justice Park's order, one of the issues that is going to be sorted out is limitation. And it would not make sense, in my respectful submission, to be construing the issue that is identified as at trial as being one of the points remaining in issue, particularly when it is expressly designated as a GLO issue, to construe that issue in a way that would rob it of wider effect. That's not a sensible way, in my respectful submission, of approaching the interpretation of what's actually at issue in Prudential. What the parties needed to know is, to what extent are these claims in time? We can all say, as a matter of principle, any claim in Woolwich is barred by a 6-year limitation period. It operates slightly differently for mistake because you have 6 years from the date of discovery, actual or constructive, to issue your claim. And if you issue a claim within that time, you can go back as far as you like. That would be one way of answering the 248 sub 1 issue, but it would be an abstract and not very useful way of answering the issue. When you look at this in the context of the GLO and what 19-23(1) is doing, one's looking to identify the judgment or order and its binding effect. And the binding effect here in my submission is that the claim in the test case is held to be in time. And there's certainly nothing fact-specific about what Mr. Justice Henderson was doing, certainly not in this sense. He wasn't making a ruling intended to be limited just to PAC or PHL. This is the ruling on the test case. There's this point that links to this, and this came up yesterday at around 4 o'clock in an exchange between my learned friend and my Lord Justice Lewison, where my learned friend sought to draw a distinction between, on the one hand, Prudential High Court deciding that the claimants could rely on section 32(1)(c) on the one hand, and I think the suggestion was made, well, there's something different between that and answering the question, well, when could the claimants discover the mistake? That distinction doesn't work in this case because there is a ruling, and it's contained in the order, paragraph 3D and paragraph 5, that the claims go back to 1990. That ruling can only exist because section 32(1)(c) does apply. So that was point 3. Point 4. Point 4 is going to sound like a minor point of detail. It actually becomes rather more important because it's going to help to explain what it is that an otherwise order might do, and it's this. My friend said this morning that limitation in Class 8 was a GLO issue for everyone, not just in Class 8. that is wrong, and I need to show the court the order that demonstrates that it's wrong, because what this illustrates is the different approach that can be taken into the scope of the binding effect of a test case. The relevant order is an order that the Chancellor made, and it's dated the 27th of November 2017. It was sealed a little bit later. It's in the supplementary bundle at tab 11, beginning on page 109. And this is what organises what becomes the Class 8 test cases. And I don't particularly need the recitals. There's the introduction of what are called Class 8 issues at the top of page 110. So it's been agreed that there are going to be these issues. And then there was a different set of issues which are called the disputed issues, and they're in Schedule 2. But the bit I need is paragraph 1. What that does is that appoints, it's 4, yes it is, 4 claims, Fidelity, Standard Life, Schroders and Barclays. They are appointed as test cases for claims enrolled in Class 8. That is to say, they're not test cases for claimants in the GLO who are not enrolled in Class 8. And there is a list of the claimants who are in Class 8, as it happens, in Schedule 11 to the GLO, which is at page 56 in the bundle, but I wasn't going to take up time with asking you to read it, but that includes the 4 test claimants. And that, as it happens, is what the Chancellor was explaining in paragraph 6 of his judgment in Class 8, which you were shown this morning. That's at Authorities page 1098. And that actually, that order in paragraph 1, that in my submission, that would be an example of the court ordering otherwise. Because if you think about the normal operation of 19 spot 23 1, if you had a test case and you didn't actually say specifically who this was going to be binding, then learning from might have had a point. It might have been a matter for debate. Well, how far does this actually go? Who is bound by the Chancellor's judgment in Class 8? What's one supposed to do? But actually, what the court has done here is it's made an order saying these claims are appointed as test cases. For claims enrolled in Class 8.
The first step in this argument must be to say that Mr. Justice Henderson's order doesn't affect the Class 8 claimants.
And it doesn't.
Because if it did, then the Chancellor couldn't have made this order.
Sure.
And you say it doesn't because they weren't on the register. Is this right? When Mr. Justice Henderson made his order?
So for the ones not for every Class 8 claimant, but certainly for many of those claims, they were added to the register after the 28th of January.
Take the ones who were on the register. How do they get to argue limitation all over again if it's all been dealt with by Mr. Justice Henderson?
Well, because at that point in time, there was a debate, and this is why I stressed up front the point about not before dates. You could have claimants. Take Barclays. It issued its claim in 2014. It can say, if the revenue is saying, well, you're too late, it can say, actually, we're entitled to argue for a later date.
Yeah, I follow.
Because-
So you
because
say
that- because
it's
that
not
had-
inconsistent with Mr. Justice Henderson's order because it's later than the 14th of July 1998.
Yeah. That's right. So there's no difficulty in that sense. So that's the fourth point, which is what Class H is actually doing, and just to have that point corrected. Point 5 is that it is very noticeable that throughout his submissions in response, Lewison studiously avoided dealing with the point which is, in my submission, absolutely critical. And it's that the revenue is taking a position wholly inconsistent with the outcome of prudential high court. There's quite a lot of discussion about one needs to identify, it's very important to be precise about what the ruling is. People need to know what's happened. I simply say this, if you ask what a litigant would think that's a follower case that's already on the group register as at the 28th of January 2014, if that litigant reads the prudential order, they are going to think Prudential's claims have been held to be in time, mine are going to be held to be in time too, unless there's some factual distinction that might leave the revenue another argument. But if one's looking at what one would take from the order, that is what one would take from it. In his oral submissions, Lewison looked to introduce a new dichotomy. There was a submission made, I think it was said that the issue of actual discovery, that on any view would have to be determined by reference to FII, that you would need a claimant-specific inquiry. Whatever might have been decided for constructive discovery, you'd need to do a fact-specific exercise for actual discovery. That doesn't work. Once one remembers that the DMG approach, which is what was being applied in Prudential High Court, applied the key point that the mistake needs to be, the true state of the law needs to be there to be discovered. And that proposition applies both to actual discovery and also to constructive discovery. So on the view of the law that was being applied in DMG, there wouldn't be a difference between actual discovery and constructive discovery. And of course, and I'm sure your Lordship has this point, in Prudential, the finding that the claims are in time, that can only be made if both actual discovery and constructive discovery are within 6 years of the date of issue of the claim form. So that was what I was proposing to say in reply about what was at stake and what was decided on the limitation issue. I do say that there was a GLO issue of limitation, that there is the order that I have shown the court, and it has an effect which is binding under 19 spot 23 sub 1, and in particular I pray and aid the wholly inconsistent outcome for which the revenue are arguing. I wasn't proposing to say anything more about what was actually decided on preliminary issue B and on set-off, because as I understand it, my friend essentially accepted in his submissions that for preliminary issue B, it's all about ordering otherwise, because it was ultimately accepted rightly that that Mr. Justice Henderson's order was not disturbed. So I wasn't going to go over that again. In any event, I'm sure the court has my submissions on that point. What instead I was going to do was to deal in reply with a couple of important points on the question of ordering otherwise, and this is relevant both to issue A and also to issue B. My friend's starting point for this was to try to paint the position that the claimants had taken. He said it was a sort of technical challenge. It wasn't a merits-based attack, he said. That was day 1, page 128. And that can be taken in a variety of different ways. What I certainly don't accept is that this is any sort of arid or legalistic or opportunistic challenge. I am very firmly relying on the merits. In this sense, my submission is that the Revenue's attempt to reopen this point is unfair substantively, and it undermines the GLO framework and the proper administration of justice. And that's true both of issue A and of issue B. In particular, in relation to A, which affects AXA IUK, similar points apply. It's just the dates are a little bit later for GREA, but it's particularly striking for AXA IUK. It issued its claims, as we know, in 2003. It has been required to wait for over 21 years for the determination of those claims. It was stopped from pursuing its own claim by the stay in the GLO because it was parked behind the test case. And I'm not in any way criticising anyone. I'm certainly not making any criticism of the court for having imposed that stay. We all know that the GLO framework is there for very good reason, to enable claims raising common or related issues of factor law to be tried efficiently. And of course that is right, so that the system of justice can operate in an efficient and sensible way. And so it's for those reasons of procedural economy benefiting both the administration of justice and also the parties to it that course has been taken. Critically, that's in the context of 19-23, where those common or related issues of factor law, they are going to be decided through the vehicle of the test case. That's why the rule makers have said you don't need, indeed you're not going to get, your own judicial determination of your own claim. You don't need it because there's going to be a test case which is going to be binding. That's why you wait. And then to the extent that there are issues left over, you have to prove your own facts to the extent that needs to happen. There might be a quantification exercise, whatever else that is left that hasn't been dealt with in the test case, that needs to be dealt with. But that was the basis upon which AXA's claim was stayed for all those many years, was so that there would be a test case and that test case would bind in AXA's case and also in GREA's case. And yet now it is said, because the Revenue have been able to secure more advantageous rulings elsewhere in other litigation, well, AXA is not to benefit from the rulings in the test case after all. I say that is unfair and not appropriate. My friend also tried to make a point of, well, being a test case is somehow double-edged. There's a lot of work one needs to do. The test case could have been anyone in the GLO. And my friend is also ignoring the point AXA was required to contribute to the costs of the test case. Under the GLO, there were elaborate and detailed provisions. So AXA has actually paid, not all of it, but has paid in part, along with other members of the group, for that prudential test case to happen. And we know why it was that prudential was chosen as the test case, because Mr. Justice Henderson told us in Prudential High Court in paragraph 27. And one sees at the bottom of page 831 in the authorities, I think I've mentioned it a couple of times, but I haven't I've actually taken the court to it, the tenor of it. One sees at the bottom of page 831 that the tax rules for general, as opposed to life insurance companies, they were at all material terms much simpler, and the complexities of insurance company taxation do not impinge at all on the claims of other participants in the GLO who received the portfolio income as part of a fund management business or trading income. The reason Prudential's the test case is because it is thought to be more complicated and therefore actually to be raising a more comprehensive set of issues. And yet now it is years after that process was set in train, AXA is to be told, well, actually, I'm sorry, you can't benefit from the result in the test case after all. That's invidious. It's not appropriate. Now, it may well be that the revenue has been able to secure indulgence in the matter of raising new points or withdrawing concessions or whatever it may be in other litigation. And you can see some of those points being argued out, for example, in FI Supreme Court 2 and Supreme Court 3. And the decisions were made as they were made, and we can read them. None of that in my submission suggests that some sort of similarly generous approach should be taken when it comes to whether the otherwise binding effect of a ruling in the test case can be undermined, because actually there are wider principles at stake in relation to the proper administration of the GLO framework and the proper administration of justice. And it's because of that GLO framework, and particularly the fact that the claims of the follower cases, that they are being required to be determined through the vehicle of the test case, that it's not right in my submission to say, well, look at private party litigation in cases like Arnold and NatWest Bank or Virgin and Zodiac. The correct analogy, if it's anything, is actually much closer to the example that my Lord Justice Lewison put to me there, I think this morning, of the litigation between parties A and B. And then there's a different result in unrelated litigation, but parties A and B, they're still bound by the determination in their case. The test case is being used, as I say, as a surrogate or a proxy for the determination of the follower cases, and that's why, if I'm right in what I say was decided in Prudential High Court, there is an order in the test case, and that has been binding since 2013. 28th of January 2014, I suppose, more accurately. And the revenue wants that now to become non-binding 10 odd years later. And that, in my submission, really is undermining the GLO framework. Now, it's said against me, well, ultimately the job is to apply the correct law, and it's somehow wholly exceptional, or what has happened in this litigation is wholly exceptional. I don't accept that. Experience tells that the law changes actually very frequently. We saw one example of that, admittedly in Trinidad, but we saw that in my learned friend Mr. Wilmot Smith's submissions. There was the change in the law that then led to the restitution claims in Samsung. My learned friend isn't offering any principled basis for an otherwise order being made. How is one supposed to judge what is a major change, a minor change, a change that justifies upsetting the GLO framework, or one that doesn't? The court's been offered nothing as to how to make those determinations. And instead, in my submission, the driving principle with all of this is actually that one has to remember that what is being put in place is a framework for the efficient determination of multi-party litigation, and to bear in mind the critical importance of the test case in that context. And as I say, that the Chancellor's order that I showed you at page 110 of the supplementary bundle, actually that, in my submission, can fairly be characterised as being in the nature of an otherwise order. It's making a ruling as to what the binding effect of the test case is going to be. And one can think of other examples. I canvassed one, I think with my Lord Justice Nugee yesterday about it emerging that, perhaps while the GLO issues were good up to a point, they may not be good for everyone, and one may have to have adjustments. Those are sensible uses of an otherwise order. What is not in my submission an appropriate use of an otherwise order is to come along years after the event and to say, because of developments in the law elsewhere, we have to upset and turn upside down the use of the test case to determine these questions. it is, as I submitted in opening, an invitation for a very unseemly scramble among litigants to become the test case, because there is a real risk, if one is a follower case, if this sort of approach for which Banana Friend is contending is applied, that follower cases won't ultimately be allowed to benefit from the test case, and there would also be a serious incentive for litigants who have suffered adverse rulings in a test case to delay the resolution of follower cases, if nothing else, on the basis that one doesn't know what might come up. So for those reasons, in my submission, it's not appropriate for an otherwise order to be made, and that applies both in relation to the limitation point and also in relation to the set-off issue. That takes me to my response on the revenues appeal, which is preliminary issue C. So pleadings, ouster, and then the question of the significance of the income tax set-off. We've dealt with this in our response skeleton argument at Court tab 20. The background is set out in paragraphs 3 to 15 in that skeleton. And what the court will have seen is that the legal analysis of the nature of the unlawfulness in the UK system, that legal analysis developed over the course of a number of years, and that was in particular with the various decisions in the FII group litigation. The ultimate outcome of that was, of course, what has been said in FI Supreme Court 3, and I'm going to need to address you in a little bit more detail on what was decided in FI Supreme Court 3. And we now know, because the Supreme Court has told us, that the vice in the UK system, when it came to looking at the question of reliefs, losses, expenses set off against liabilities which might be said to be unlawful, that actually the vice ultimately was the inability to carry forward double taxation relief. And the Supreme Court tells us that the solution was to be found in the double taxation relief system. There was a need for that DTR to be carried forward. And as the Supreme Court tells us, and this is paragraph 146 in FI Supreme Court 3, that there is a restitutionary claim where tax has been paid as a result of the inability under domestic law to carry forward unused DTR. So that's where things end up. But it's important for the purposes of issue C, particularly when it comes to pleading and ouster, in my submission to take into account the development of the law, because that, I say, highlights three very important points. The first is that AXA, this actually is AXA IUK that brought this particular claim. I hope for issue C, if I just call them AXA, I hope that's all right, it'll save time. AXA brought a viable claim by reference to the facts and law as they stood at the time the claim was issued. What we'll see is that that claim was clearly being made as broadly as possible. And that, no doubt, was because of uncertainty that existed both in relation to the impact of EU law, so what was the unlawfulness, and as to how, if there was unlawfulness, how that unlawfulness was to be remedied as a matter of English law. So that's point one. Secondly, and this is really putting the same point another way, in my submission, one can't say that there is anything in any way abusive about AXA making the claim that it did at the time that it did. Thirdly, what has happened since the claim was issued is that the developments in the law and in the legal understanding, they show that AXA was absolutely right in its contention that the UK dividend taxation involved unlawful discrimination. And there is no substantive contest other than on issue C sub 3 in the income tax set-off point, which I'll come to. But for leaving that point aside, the revenue doesn't dispute that as a matter of law, AXA would be entitled to restitution of the monies paid over to the revenue, either pursuant to unlawful statutory provisions or under mistake. What we have instead is a pure pleading point, and what I'm going to do is to explain why it is that the pleading point is bad. But before I get to the pleadings...
Sorry, you said, can I just clarify, you said entitled to restitution, I think either under statute or on law, but the statutory... Can you clarify that?
If I said under statute, I didn't mean to.
Because there's no, as I understand it, there is no debate. You could bring a statutory claim.
What I was trying to say, and I'm very sorry if I mangled what I was trying to say, I was trying to say that there is no dispute, subject to the pleading point and subject to the point about income tax set-off, that AXA has, it's a common law claim. It's either in mistake of law, or it is for tax demanded pursuant to unlawful statutory provisions. That was where in my note the reference to statute came in. I wasn't trying to. So a Woolwich claim was all I was trying to say.
But it's subject to the ouster.
I'm so sorry.
Subject to the ouster.
Oh, and subject to the ouster. Yes, of course, and I'm going to deal with that. What I was simply trying to say was that the only substantive debate is on the income tax set-off point. I'm characterising the pleading point and the ouster point as procedural points. And just anticipating a point that I will need to deal with, there is a debate as to the extent to which a statutory claim is available at all in relation to a situation like this. And I flagged that in the skeleton, but that's something I'll have to develop in a little more detail, because working through that takes a little bit more time. What I want to do is to take the court briefly through the cases to show you the development of the law, but anticipating what I'm going to get out of those cases. There are three particular things that I want to show you. The first is that what we're dealing with here is an additional unlawfulness in the UK system. And that unlawfulness is over and above the UK's failure to give credit at the foreign nominal rate of tax. It lies in the fact that the UK system prevented the carrying forward of double taxation relief. And the reason for that, as we'll see in Saladin, actually ties into the original receipt of the dividend income, because the mischief is that it's that original dividend income that is being subject to indirect economic double taxation. So the vice ultimately goes back to the UK dividend tax provisions, and it's a facet of the lack of equal treatment that arose from having the exemption system for dividends from UK resident companies and instead having a credit system for dividends from overseas companies. And as we'll see, the existence of that unlawfulness and the consequence of that unlawfulness in terms of remedies, that gets established in July 2021 in FI Supreme Court 3. Prior to that, the state of English law was that claims of this nature failed. That was FI Court of Appeal 1 in 2010. That was what was overturned in FI Supreme Court 3. And thirdly, what one will see from the history of the development of understanding on this area is that at the time when these claims were made, the response to the unlawfulness in the UK system that could have been made in a variety of different ways, and I'll show you some of them when we come to look at FII, High Court 1 and Court of Appeal 1. But if I can just start with the chronology, if I may, it all starts, I wasn't proposing to take you to this, but it does all start with part of question 6 that was referred to the Court of Justice in FI CJU 1, and that was all to do arising from the fact that reliefs had been expended against unlawful tax liabilities. And what the Court of Justice did, and one sees this then echoing particularly in FII High Court 1 and FII Court of Appeal 1, is that it gave general guidance about the San Giorgio principle.
Mr. Bremner, I have not lived with this case or this set of cases for as long as you have. You tell me issue 6 and the reference to CJ. You have no idea what that.
I'm very sorry. I am sorry. And yes, it may not be the most popular thing to do at 4:05 on day 2, but I'm more than happy to show you, Lordship. I'm very sorry.
I just want to understand what the point is. You can do it by reference to FII High Court 1 if you like, but
I was hoping to avoid having to show you yet another judgment. Was all I was really trying to do. But it may be that I can't avoid it. In fact, because what one sees. So, if I just explain it at a high level first, and then I'll show you the paragraphs. There is a question referred in FI CJU 1 that looks as if it's going to raise issues about what claims can be made where reliefs are used up against tax. The Court of Justice gives only, on analysis, quite a partial answer to that question. It gives general guidance about what the San Giorgio principle does, and it looks at 2 types of reliefs, and it says they're not within the San Giorgio principle. It doesn't say anything more. And so when the case goes back, there's then a lot of argument in High Court 1 and Court of Appeal 1 about what has actually been decided, what's the effect, what claims can actually be made. And the focus at that point is actually on the use of the reliefs. So your Lordship will recall the example given by the judge. So say you've got a receipt of dividend in year 1. There's use of losses, for example, against it in year 1. There's actually no tax to pay. However, there's a larger tax liability in year 2. When we're at the stage of ECJ 1, High Court 1 and Court of Appeal 1, the focus is very much on what's happening in year 1. And does that give rise to a restitution claim? And held not, as we'll see. So if I can just start with showing you question 6.
what are we looking at?
So we'll need the judgment on the first reference, which is within tab 43, which should be within volume 4.
Tab
43, within volume 4. The report starts at page 1609.
So this was a reference made at a very early stage, by
yes.
Mr. Justice Park.
Yes, I think it was Mr. Justice Park, yes.
Before there was any
Before there had been-
substantive
Correct.
UK judgment.
I think the strict position is that a trial started, but was then immediately adjourned for a series of questions to be referred.
Because it was obvious you'd need.
That there would need to be those rulings. I believe that's right. So So the strict position is that there were proceedings, the trial commenced, but then was adjourned for this to happen. And there is a particularly long list of questions which start at paragraph 31 in the Court of Justice's judgment, page 1657. And they start by raising questions, please don't read through them, about the lawfulness of the UK regime. It's 6.
Short question itself.
Well, yes. Six raises a series of questions about remedy, including in particular about the use of ACT and the use of reliefs. And you can see, for example, the use of reliefs in 6, Romans 6, by the letter F. And what the Court of Justice does is it deals with question 6, among other questions, starting at page 1680, paragraph 197. And it treats this as a debate about the classification of the remedies in the event that unlawfulness is established. And one of the paragraphs which becomes important in front of Mr. Justice Henderson and then the Court of Appeal in 2010 when the case goes back is paragraph 205, bottom of page 1681. And that's where the court is setting out what it sees as the scope of the San Giorgio principle. And of course the significance of that's the repayment remedy. There's no need to establish sufficiently serious breach if the San Giorgio principle applies. And the words in the judgment that particularly come under debate, it's the scope of what is meant when the court says not only of the tax unduly levied, so that was my friend's example about actually paying over the corporation tax, but what are these other sums which, quote, relate directly to that tax? How broad is that? And as we'll see, one of the things that gets argued out is how do you deal with use of reliefs in that context? And then 206, they deal with ACT specifically, and they say that you get repayment of that. But then what they do in 207 is they look at these 2 particular instances of waiving reliefs. And the court says, well, those are not within the San Giorgio principle. That's a very bare bones summary of 207. And it's only those 2 things that the court focuses on. So the Court of Justice says, well, these 2 things, waivers of reliefs, they're not within San Giorgio, but it's common ground when the case goes back that what the court was not talking about was, for example, the application of management expenses, group relief and the like. It was other reliefs that were not to do with that. And so all that has come back from the Court of Justice at this point in time is this quite general guidance about the scope of the San Giorgio principle. So it's the tax itself, but also sums that relate directly to that tax. And then it's known that there are particular reliefs where essentially the connection is too remote, so they're not going to be within the San Giorgio principle. And those are not going to be got back. But other matters, like, as I say, application of losses or management expenses, they're not covered by 207. They have to be argued out when the case gets back before the English courts. And that's exactly what happens when the case gets back in front of Mr. Justice Henderson in 2008 in FII High Court 1. And I'll probably just show Your Lordship this in the time I have left today, and then that's probably a convenient moment then to embark on the court.
Yeah, all right, well, let's look at Mr. Justice Henderson.
Convenient.
That's Which bundle?
And that should, I think, be in bundle 3. No, sorry, 2.
Two.
Bundle 2. Tab 24. And if I can ask your lordship to pick it up at paragraph 210, that's at the bottom of page 495. So this is looking at surplus ACT, loss relief, other expenses, losses or relief set against the unlawful case 5 liability. And you can see the mistake relied on was pleaded in alternative ways. So first of all, the use of the relief was ineffective. And so take the example of expenses, that they were unaffected. And then secondly, if there was a valid use of, say, the reliefs, the mistake was in satisfying the case 5 liability. And they wanted back the amounts of tax thereby satisfied by mistake.
So both of those relate to the tax
At that,
paid in year 1. if
at
you
that
like.
stage, that's what the focus is on. Yes, absolutely. And then I can pass over the compensation claim because that would have needed sufficiently serious breach. Then there was an alternative claim that the reliefs continue to be available to the claimants, or if they've been extinguished, then community law requires their reinstatement. So there are a lot of different things going on in terms of the assertions that are being made. And you can see the pleadings that were being relied upon by BAT for that purpose to some extent, because Mr. Justice Henderson sets out the relief that was claimed in paragraph 201 at the bottom of page 493. And there's declaration sought as to the illegality of ACT provisions, FIT provisions, dividend provisions as defined. 2 is restitution, and then 5 is the declaration that he mentions in paragraph 211. So there are these various different potential routes to recovery articulated. All of them are rejected, and you see the rejection of paragraph 276. Paragraph 276, which is on page 512. So Mr. Justice Henderson was unpersuaded that these were a direct or an inevitable consequence of the unlawful tax charge, so they weren't San Giorgio claims. That's why the claims were rejected in European terms, and he'd already at 270, and this was a passage from Learned Friendship, he'd looked at it more from an English law perspective, paragraph 270 at 510. And it's a similar point. It was seen as this being to do with consequential steps taken rather than any sort of direct payment of tax. And what we'll see tomorrow morning is that that's maintained in the Court of Appeal, and then the nature of the analysis rather moves on because of the Salonen case. But that's probably a sensible point to break now with your lordship's permission.
Yeah.
What I'm supposed to do in the morning is complete the chronology to FI Supreme Court 3 so we can see what the legal basis of the claims is, and then I'll deal with what's been pleaded and why the pleading supports the claim that's maintained, deal with the ouster, and then deal with the income tax set-off point.
Right. 10:30 tomorrow.
on the 12th.
What lies it for?